And that's the million-dollar question. When family and law collide, emotion always loses to evidence. The court doesn't care who built memories in the house. It cares who holds the title. But how far will Daryl go to defend what he calls home?
Family Feud meets courtroom showdown. The Westborne Family Trust is evicting its own trustee's brother, Daryl West, from a property he claims is his home for life. Attorney Mark Lando represents the trust seeking to sell the asset, while West, representing himself, drops bombshells, an ongoing Court of Appeals case, number 37500, allegations of fraudulent court filings, and a claimed lifetime right to live there. But Judge Michelle Evans isn't buying it. She warns West his arguments are irrelevant, setting up a brutal clash over property rights versus legal procedure. With West revealing he's an amputee and alleging $25,000 in personal repairs, this isn't just an eviction, it's a raw family implosion with life-altering stakes.
This right here is the trap so many fall into: confusing bloodline with ownership. You can share DNA, but not deeds. Legally, the trust owns the property, not the people tied to it. Harsh, maybe, but in probate and real estate law, sentiment doesn't stand up in court.
Who deserves the house? Let's dissect the drama.
Court does call the case of Westborne Family Trust versus Daryl West.
Mark Lando on behalf of plaintiff.
Mr. West, state your appearance.
Daryl West, present.
Okay, where are we on this case? I'm afraid to ask.
Judge, this is a termination of tenancy action. My client is the owner of property. Mr. West is the trustee and the trustee's brother. He's been living there a lot of years, and they are estranged. And my client just wants to get the property back, sell it, and that's pretty much the long and short of it.
It's not the long and short of
All
it.
right. Well, I've read everything that you submitted, Mr. West, much of it irrelevant to these proceedings, quite frankly. The only thing that I have that may be of some relevance, is there a matter pending in the Court of Appeals?
Yep.
Immediate tension. The plaintiff's attorney frames this as a cold business decision. The trust wants the property sold. But West's presence hints this is deeply personal. Legally, termination of tenancy actions are usually straightforward, but family dynamics change everything. The judge's "I'm afraid to ask" foreshadows chaos.
Now here comes the desperation pivot. Daryl's hoping for a jury, maybe thinking sympathy can save him. But tenancy law doesn't usually give that luxury. Without a valid claim of ownership, this stays a bench battle, and judges rarely gamble with procedure.
Key legal point, being the trustee's brother grants zero automatic rights. Trust assets belong to beneficiaries, not family. West must prove a legal interest beyond blood ties. The attorney's blunt long and short of it downplays the human drama about to explode. Would you evict a sibling?
Absolutely. Case number 375000.
Your Honor, Mr. West filed a motion to stay the eviction case that was denied.
That's not exactly
in the Court
correct.
Of Appeals?
It was denied with the Court of Appeals.
All right, thank you.
Judge, that's not exactly correct. It's a misleading statement. Actually, what happened was filed an interlocutory appeal, and the circuit court went ahead and ruled while that interlocutory appeal was pending. Therefore,
Procedural minefield. West references case number 37500, likely an appeal of a related circuit court ruling. Plaintiff's attorney claims a stay was denied, but West counters it's an interlocutory appeal dismissed on technical grounds. This is critical. If West's appeal challenged the trust's ownership or his occupancy rights, it could impact this eviction. But the judge shuts it down hard. No stay? No delay. Legally, she's correct absent a binding order. Yet West's insistence suggests he believes the appeal invalidates this case. Is this procedural ignorance or a legitimate grievance? The judge's impatience is palpable.
I filed a right of appeal and let the interlocutory appeal be dismissed. And it was on that basis that the interlocutory appeal was dismissed based on the current pending case. And there's still on the docket a motion.
But there is no stay of these proceedings.
There is a motion for stay of these proceedings on the 375000 case.
All right. Well, you're going to have to get to them because I don't see here that I've got a tribal issue. I am not going to stay these proceedings. And so if the Court of Appeals are indicating
And that's the
something
dagger.
different.
No file document.
Am I
no
entitled
legal
to a
stand.
jury trial?
In court, if it's not in writing, it doesn't
If I don't
exist.
have a, if
The
I
judge
don't have
isn't
a tribal
heartless.
issue, no,
She's bound
sir.
by record. One
Judge,
missing form
there's
just cost Daryl his best
promissory
argument.
estoppel,
If he wishes to stay it, then the Court of Appeals can stay it. Mr. Lando has indicated that they denied it. You're indicating something different.
Am I entitled
than
to a
that.
jury trial?
If I don't have a tribal issue, no, sir.
Judge, there's promissory estoppel, there's quantum meute, there's a written documented contract documented and subscribed by the plaintiff.
The heart of the case. West drops his nuclear claim, a lifetime occupancy agreement signed by the plaintiff. If proven, this could be an equitable life estate, a legal right to live there until death. But the judge finds no such document in evidence. This is devastating. Without filing proof in this case, his claim is just an allegation. Legally, he must formally assert this interest via a counterclaim or separate action for the court to consider it. The judge's directive, file paperwork in circuit court, highlights a fatal self-rep mistake, failing to properly plead his defense. His strongest
You can
argument
feel the frustration here. Daryl's arguing morality in a system built on paperwork. He fixed the house, invested his savings, but never secured a written agreement. In equity, that's tragic. In law, it's irrelevant. The court doesn't pay for loyalty, it pays for proof.
dies on a technicality.
All of those are not tribal issues that grant you possession of the premises, sir.
The document subscribed by the plaintiff grants me premises occupancy.
I disagree. It's not a tribal issue for me, sir. You show me nothing that gives you claim to those premises.
I submitted the document where the owner of the property granted me living arrangements to the property. That's in the file.
For how long, sir?
For the balance of my life.
I do not see anything in here representing a life estate. If you are claiming that you have a life estate, then you need to file the appropriate paperwork.
It's
in
not a life
circuit
estate,
court.
Judge.
You need to file the appropriate paperwork in the circuit court so the circuit court can make a determination as to whether or not you have a life estate of some type on the premises. But I do not see that. I do not see any defect in the notice which has been provided by the plaintiff in this case. I have nothing to try.
Please address their complaint. Their complaint clearly files misleading information. In item 2, counsel says there is no other pending or previously filed document or court actions. And in fact, there was a circuit court action and it's under appeal now. Therefore, that's misleading statement. Furthermore, in
Scorched earth allegations. West accuses the trust of perjury in the eviction filing, 1. Denying pending litigation, while case number 37500 exists, and 2. Claiming property maintenance compliance. He reveals the trustee admitted under oath in another case to zero contact in 10 years, contradicting the maintenance claim. This is legally explosive. Knowingly false pleadings can lead to sanctions or dismissal. But the judge dismisses its relevance to possession. Here's why: even if true, it doesn't negate the notice to quit or prove his right to stay. His remedy? Sue for fraud separately. A brutal legal reality check.
Which has no relevance to this court and its decision, because this case would not have gone up to circuit court.
This case was already in the circuit court on a parallel.
No, sir. This case is a district court case. This case, regardless of what plaintiff said, would have been filed and resided right here before me.
Judge, can I go on further to the complaint?
Not if you're going to waste my time.
I'm not.
Yes, you are, but go ahead.
In Section 8, plaintiff and counsel suggest to this court that the property owner has maintained that property in accordance with state law as it's a residential unit. That is absolutely a false statement. She has stated in a statement of facts and a motion at the circuit court that she hasn't communicated or been in contact with the resident occupant, Daryl West, in 10 years. She has not maintained the property in accordance with Michigan law. Furthermore, because I had to maintain
the $25,000 gambit. West claims he invested heavily in repairs, implying unjust enrichment or a constructive trust. Legally, this could create an offsetting claim, but not a defense to eviction. Quantum Marut, payment for services, requires proof the owner requested the work.
And here's the twist of humanity. Even after winning, the plaintiff offers Daryl more time. It's mercy cloaked in procedure. The judge still enforces the law, but this moment shows something rare: empathy without compromise.
Without that, it's just a voluntary expense. The judge's silence here speaks volumes. Unreimbursed repairs don't grant possession rights. Worse, it undermines his lifetime agreement claim. Why pay $25,000 if you own it? This emotional plea backfires, painting him as financially entangled but legally unprotected.
I spent $25,000 of my money to keep the property maintained. She has completely falsified the complaint, Judge. She did not provide adequate maintenance to the home in reference to Section 8 of the complaint. That's a false statement. There's two false statements provided in the complaint, and the court should order a show cause hearing at the very least and should actually dismiss this case.
Are you done?
Yes.
It still is not an issue related to the termination case. If you believe that there's a money case that needs to be filed, then you may do so.
Judge, one last point.
I thought you were done.
I was until you made that comment.
Sir, I might suggest that you get yourself an
Judicial warning shot. The judge's advice to hire counsel isn't kindness, it's frustration with West's procedural missteps. He's arguing equities, fairness, in a summary proceeding focused only on legal possession. An attorney would have 1. Formally asserted the life estate claim, 2. Moved to stay based on the appeal, 3. Filed a counterclaim for the $25,000. Instead, West wasted his hearing on legally irrelevant arguments. The judge's "I've let you go longer than normal" confirms he's losing credibility. This is the self-rep trap. Passion without strategy equals certain loss.
attorney to represent you.
Can you adjourn it?
Because the termination
While I do?
case, nothing has been filed before me that gives me anything to try as a reference a termination case. I'm going to keep saying it. There's nothing that you're saying to me right now. I've let you go on far longer than I would normally let anybody else go on regarding this. If you have one more thing to say to me, you may, and then I'm going to have my word.
Have your word, Judge.
Court finds that there's no tribal issue as to the issue of possession in this matter. I will grant judgment to the plaintiff for possession with a writ to issue in 10 days.
Wow.
From the signing of the order.
Judge, as much as I appreciate the court making that ruling, I'm willing to give Mr. West additional time. My client is his sister, and even though they're estranged, she knows that this is going to create a hardship for him.
In the end, this wasn't just a legal defeat. It was a family fracture written into record. Daryl fought with heart, but heart doesn't file motions. This case is a reminder. In property law, emotion is evidence only in the court of public opinion.
He is an amputee, and it's going to take him some time to vacate. I want to give him the comfort of some additional time.
So here's what I'm going to do, Mr. Lando. I understand that. So I'm going to issue my judgment. What the parties work out, you can work out. But I'm going to issue the judgment as I pronounced.
Very good.
Thank you.
I'll submit the judgment.
The verdict? A masterclass in procedural rigor versus emotional claims. The judge granted possession to the Westborne Trust because Daryl West failed to prove any legal defense to eviction. His lifetime occupancy claim lacked documented proof filed in this case. The pending appeal, number 37500, had no active stay halting proceedings. Allegations of fraudulent pleadings required a separate action, not dismissal. His $25,000 in repairs didn't establish possession rights. The plaintiff's offer of extra time, citing West's amputation, was strategic grace, not legal concession. Court takeaway: courts rule on evidence, not hardship. Without proper documentation and procedure, even compelling stories lose. Fire, was West wronged, or did he squander his chance? Should family